Hey everyone, thank you so much for the feedback on the case study of Big Basket versus Daily Basket. The strategy which has been followed by Daily Basket, given the fact Daily Basket is an SME and they opted for coming online and illustrating the public notice for the consumers to see, and whether this strategy is a good strategy or more SMEs globally are going to take up this strategy without going to court are the questions we need to answer. So, first of all, let's talk about the fact whether Big Basket is similar to Daily Basket. Except the fact, the common word, basket. However, that doesn't give them the monopoly to be in the market, and given the fact there were other trademarks such as nature basket and there are other domain names also working in the same forte. Now the question arises whether Big Basket should have sent the legal notice at the first place to Daily Basket. From understanding point, it is important to sensitize the competitors about the trademarks and trademark protection. So, from that viewpoint, sending a legal notice at the first place by Big Basket to Daily Basket re emphasizes the point that IP protection is important. The first step in analysis of any two trademarks is to identify the similarity and what is dissimilar between the two trade names. First of all, both are logos, and stating the fact the logo has to be seen as a whole. Color combination is different. Big Basket is one word and Daily Basket are two words. Both marks in terms of identification from the consumer point of view would be different. However, when a legal notice is received, the general practice should be to respond to the legal notice. Due to the current situation, it might have struck the SME, which is Daily Basket in this case, is to find a cost effective strategy to mitigate the risk and talking about it in the online media. The fact of matter here is due to Daily Basket coming online and giving an open fight in the online world led to trolling of Big Basket by the consumers. What was the result? The result has been in the online media that Big Basket came up with a solution which stated that we want to find a middle ground to solve the whole process, and they would initiate a conversation with Daily Basket. Daily Basket is catering in a particular town in India. However, Big Basket has been catering the whole country. This strategy of Daily Basket helped them to initiate a conversation with Big Basket. However, legally, this might not be a good move because Big Basket could have filed a case of defamation before the court of law. Given the fact and after analysis of the two trademarks, it is very evident that both are different even though they are serving the same customers, or the segment is the grocery sector, or I would say the household things are being sold on the website. Now, coming to the user interface of the website, both are simple UIs which has been utilized by different companies in the online world. Now, what are the proactive steps any SME can take to increase their protection in terms of trademark? A very important factor which should be considered from the legal point of view is to file multiple trademarks to develop a trademark portfolio. In many cases, businesses start by being an aggregator in the online world, which in case Big Basket and Daily Basket both are aggregators. So, what is the strategy here? Filing trademarks in different clauses to increase the periphery of protection and the description of the trademarks while filing a trademark application. There was a trademark Foodie Bay, and eBay had opposed Foodie Bay, and they were at the very initial round of their business. The day the opposition was filed by eBay, Foodie Bay changed their business model, or I would say the brand name of the business model, to Zomato. And today Zomato is a big player not only in India but on a global basis. So what are the learnings from these two case studies would be seeing the fact that internet has become a tool of communication. SMEs are reluctant to go before the court to get justice. However, stated by some groups, they should have approached Big Basket to come to an agreement that how they want to do their business in the respective states, which I believe Big Basket would have taken an advantage because Daily Basket is an SME. However, when they came online and people supported them, Big Basket was forced to state the fact that they want a solution. So I believe the best things for SMEs is to do their trademark research well. In this logo itself, if they would have added a tagline, then both the marks would be totally dissimilar because it has a tagline also. So developing a number of trademarks on a yearly basis is a good strategy. So probably the big players, while sending any kind of legal notice, they should include this clause so that any SME think twice before publishing such kind of document in the open domain. If you have any questions related to this case study or any trademark related inquiry, I'll be happy to talk about it. Thank you so much and have a great year ahead. Bye bye. Take care.